So good evening, members. Welcome as we digest the great SOPPEC rule. And statistics may say that people fail professional ethics because they don't interpret the SOPPEC rules rule by rule to understand its rationale and what the framers of this great document intended to bring on board. So if you have a look at the screen, I have prepared some notes and some interpretations of the various rules, and I'll be reading first, then we understand how I have analyzed the same. So if we start directly with SOPPEC number 1, SOPPEC number 1 is giving a requirement for a practicing certificate for every advocate. So it is a professional misconduct for any person who has been admitted as an advocate to engage in the practice of law without a practicing certificate valid for the practice year, or to allow his name or her name to be used by persons not qualified to practice law and to offer legal services. One of the key importance of SOPPEC number 1 is that it continues to define who an advocate is, and this is borrowed by a person from Section 9 of the Advocates Act that defines who a qualified person to be an advocate means, and he means that it amounts to one who has been admitted as an advocate and his name is for the time being on the roll of advocate and he has in force a current practicing certificate. So remember, this is a conjunctive test. It has the word the conjunction and, so it is not to be read in seclusion. So maybe at times students usually omit in writing the correct definition of a qualified advocate to mean he has been admitted, he has gone through Kenya School of Law, admitted, he has petitioned the Chief Justice to enroll his name in the roll, and his name is still in the roll and he is not struck out or suspended, and he has in force a practicing certificate. Those are the tests. Okay. Then SOPPEC number 1 still continues to tell us that Section 31 it is to be read in tandem with SOPPEC number 1, in that Section 31 prohibits an unqualified person from acting as an advocate. Okay, that is the reason why I have already projected Section 31 before you. And Section 33 of the Advocates Act is also important in that it makes it an offense to pretend to be an advocate or to use any name, title, or description implying that the person is an advocate or recognized by law as qualified to act as an advocate. So maybe students, when they want to tie SOPPEC 1, they omit to give various enabling offenses that emanates from a person who pretends to be an advocate, pursuant to Section 33 of the Advocates Act. Then Section 37 of the Advocate Act is also very important because it prohibits the sharing of profits with an unqualified person. Okay. The main goal of why we are dissecting this is that we can link the SOPPEC rule and the Advocates Act, and when we will be approaching the professional ethics paper, we will not be cramming. Okay, so of key importance, I've mentioned Section 31 that prohibits unqualified person from acting as an advocate, and if that unqualified person acts as an advocate, he faces the offense that has been stipulated under Section 33 of the Advocates Act. Then Section 37 is also prohibiting in nature, in that you can't share profits with an unqualified person. Okay. Then Section 34 of the Advocates Act is also important when you are interpreting SOPPEC number 1. In that Section 34 prohibits an unqualified person from preparing certain documents. Let me confirm if this session is being recorded. Section 34 prohibits an unqualified person from preparing certain documents or instruments, including relating to conveyancing of property, incorporation of a company, a partnership agreement, probate or letters of administration. Okay, so it is very important for students to know which documents cannot be prepared by unqualified persons. And by unqualified person, you do not meet the threshold under Section 9. Okay? You're not admitted as an advocate, your name is not on the roll, and you don't have a practicing certificate. So the examiner can coin this situation to say that an unqualified person, okay, this person has not taken out a PC. So the examiner can be smart. He wants to test you whether you understand the conjunctive nature of Section 9 of the Advocates Act. and they tell you that a person has been admitted as an advocate and his name is in the roll, but he has not taken out a PC for that year. And this person goes ahead to prepare. They know about conveyancing documents, but they prepare incorporation of a company document, they prepare a partnership agreement of that company, and they also help a widower to secure. Okay? They help a widower to secure shares of a deceased director. So they will be testing your understanding of Section 34 of the Advocates Act and your understanding of Section 9 of the Advocates Act. And then SOPPEC 1 still continues to tell us that Section 40 includes that cost shall not be recoverable where an unqualified person acts as an advocate. So you can't forget that. You can't claim cost where a person acted as an unqualified person. You being an unqualified person cannot enforce for cost. That is straightforward. Then Section 41 continues to tell us that advocates should not employ persons who have been struck off the roll or suspended without the permission of the council. Okay? Then critically, a student should be in a position to understand that there was incorporation of Section 34B of the Advocates Act that gives validity of legal documents that have been drawn or prepared by an advocate without a valid PC. Because those documents will remain valid, but the cost will be awarded or the penalty will be faced by the advocate. Okay? Practicing advocate who fails to take out a PC commits a misconduct. Because SOPPEC number 1 directly tells you so. It is a professional misconduct for any person who has been admitted as an advocate to engage in the practice of law without a practicing certificate. That is a professional misconduct on its own. Then the advocate can be told to pay cost. Okay? Those are 2 avenues where you can enforce. Then examiners have adopted a certain angle of asking questions when it comes to professional ethics. They ask you, what is the rationale of this provision? And the rationale is directly provided in the SOPPEC rules. In that, statutory provisions prohibit the practice of law by an unqualified person. This is due to the fact that whereas an unqualified person may well be capable of advising or representing another in a legal dispute or undertaking conveyancing or corporate work, such person is not subject to the control of regulatory bodies, including the society. In the case of misconduct, an unqualified person not being a member of the society is not subject to disciplinary procedures of the society and the ACC, Advocates Complaint Commission. And that is the rationale. Okay? Maybe the examiner will be giving you 3 marks for that question. There is another rationale. An additional reason for the prohibition arises from the fact that the client of an advocate authorized to practice law has the protection and benefit of advocate-client relationship privilege. The advocate's duty of secrecy and the authority that the courts exercise over advocates. The client also has rights in respect to taxation of bills, rules respecting operation of client accounts and professional indemnity cover, all of which provide the client with rights and protections that assure quality service and recourse in case of a professional misconduct. So key takeaways from the rationale in this SOPPEC number 1. We can say that there is a regulatory body and an unqualified person will not be subjected to the regulations. Additional reason is that the advocate-client privilege will be protected where there is a qualified advocate. Okay? Because we have seen that an unqualified person cannot claim for cost where the client is represented by a qualified person. That means the client has the right to taxation of bills. Okay? So those are three key rationales that a student should not cram, but it should come out clearly. And generally, before we go to SOPPEC number 2, SOPPEC number 1 tells us the scope of the standard. Because this standard requires the advocate to ensure that 1, he has a valid PC, he does not lend his name and reputation as an advocate for use by an unqualified person. Lending out your name is prohibited. And you should take full responsibility where required, appending your signature to a document for all business in respect to which you have been instructed. 4. Does not maintain a branch office unless there is posted at the branch office on a full-time basis a duly qualified advocate. So from SOPPEC number 1, we can borrow that you are prohibited from opening a branch office where there is no a qualified advocate in it. E. Does not, without the approval of the society, employ an advocate who has been suspended or struck off. Because we analyzed the Advocates Act, and we saw that for you to employ a suspended person or a struck off advocate, you should seek the permission from the society in writing. Okay? And it is also a standard being enforced by SOPPEC number 1 to report to the society instances which come to your knowledge of an unqualified person practicing as an advocate. This person could have stolen your identity, so it is upon you to report to the society, person to SOPPEC number 1. Then lastly, if an in-house counsel employed by an unqualified person does not draw documents or render legal services to his employer, for which fees are charged directly or indirectly by his employer and retained by that employer. This is very critical because I can read it verbatim again. If you are an in-house counsel employed by an unqualified person, it can be a company that has employed you. Okay? You should not draw documents or render legal services to the employer for which fees are charged directly or indirectly by his employer and retained by that employer. SOPPEC number 1 prohibits an in-house counsel from drawing documents or rendering legal documents for which fees are charged directly or indirectly by his employer. We have the Advocates Practice Rules. If you read Rule 4, it has given various exceptions where the employer is an unqualified person and where they are allowed to take a bite, in quotes, of the profits being generated in this activity. Okay? It is not black and white for unqualified persons not to employ advocates. That is allowed. Advocates Practice Rules. Okay? But there are exceptions. One, where the amount is being used to offset the advocate's day-to-day running of the office. 2, where the amounts are being paid to retired advocates from that office, and these monies are being paid to his beneficiaries. Those are the exceptions to it. And if you are an advocate, if you are a candidate sitting for professional ethics, that can be a loophole. And the basis is SOPPEC number 1. You can't draw documents or render legal services where the employer is directly or indirectly trying to recover the fees, because those fees should be used to offset the advocate's salary. Then the remainder should not go to the employer, but the remainder should be used to offset the normal running operations of the office. If you read why the Advocates Practice Rule number 4B, 4A was introduced, is because the rules contemplated a situation where if I leave an unqualified person to be enjoying the fees that this advocate is generating directly or indirectly, we will have a situation where unqualified persons are touting for their businesses, because we will have left a vacuum in that an unqualified person can run a law firm like a shop. So we will have seen a lot of touting and advertisements, because every unqualified person wants to accrue the best of the best when it comes to these profits. And that is the reason why, if you read section 37, an advocate is prohibited from sharing profits with an unqualified person. There could have been a lacuna if that provision had not been enacted. Section 37 of the Advocates Act. Okay, so before we go to SOPPEC number 2, I have tried as much as possible to explain. And before you can see various decisions that bring forth a ratio decidendi. If you read the Standard Chartered Bank Kenya versus Mechanical Engineering Plant 209, the ratio decidendi was that an advocate must hold a valid practicing certificate at the time of filing or acting. Okay, that matter is settled. I will not delve deeper. I'm looking for a ratio decidendi where students will confuse. Students usually confuse between the Supreme Court decisions, National Bank of Kenya versus Anajo Warehousing, and we have another one known as the Wilson-Dolo IR decision. Always note that the National Bank of Kenya Limited versus Anajo Warehousing Limited 2015 is the Supreme Court decision that reinforced Section 34B of the Advocates Act. It is pursuant to this decision that Section 34B of the Advocates Act was introduced. And the ratio decidendi was that Section 34B purpose is to penalize an advocate or an unqualified person not to void conveyancing instruments to the prejudice of clients and third parties. And invalidating documents will cause disproportionate injustice and undermine commercial certainty. That is a potential question in orals. Okay? And then I've emphasized on the ground that an unqualified person cannot recover cost or fees. Where do students go wrong when they are doing an examination? They assert that any pleading or document is automatically null. They don't know the current progression of the law when it comes to that part. And they fail to distinguish an advocate on the roll but has no PC and an advocate or a struck off or suspended person acting. Okay. Students ignore the burden of proof. You must prove the missing PC for the specific year, person to due drop decision. Students forget about cost and fee consequences. Even if documents remain valid, fee recovery can fail and a firm can be declared illegal, person to see decision above. And students miss Section 34B entirely. Okay, so that is it. Now we are going to analyze SOPPEC number 2. Actually, this will be a lengthy topic, but very worthwhile. SOPPEC number 2 tells us that the rule of advertising and marketing is restricted. And SOPPEC number 2 tells us that except to the extent permitted by the advocate's marketing and advertising rules or any amendment or replacement thereof, it is a professional misconduct for an advocate directly or indirectly to apply for or seek instructions for professional business or to do or permit in the carrying on of his practice any act or thing which can be reasonably regarded as touting or advertising as calculated to attract business. Okay. SOPPEC number 2 proceeds to tell us that it is a rationale emanating from this prohibition that it is important that a person requiring legal services is able to access information about the advocates qualified to offer the kind of legal services the person seeks. Advertisement of legal services by the advocate may assist members of the public to access appropriate legal services. Okay? And what are the scopes of standards that we can borrow being advocates? An advocate should solicit for work by means that are compatible with the integrity, independence, and dignity of the profession. Accordingly, an advertisement or marketing by an advocate shall comply with the provisions of the advocate's marketing and advertising rules, not detract from the integrity, independence, and dignity of the legal profession, not mislead uninformed or vulnerable members of the public, not mislead any uninformed or vulnerable members of the public, not to arouse unattainable hopes and expectations, or be so undignified or offensive as to be prejudicial to the interest of the legal profession or public interest. That is what SOPPEC 2 provides. Okay? And you as an advocate, you have a duty to ensure that before making a public statement concerning a client's affair, the advocate is satisfied that any communication is in the best interest of the client and within the scope of the advocate's engagements. And when making a media appearance in the context of a legal brief or in a non-legal setting, the advocate should take care not to convert the media appearance into a marketing opportunity by seeking to encourage publicity for himself in the media reports of the case or transaction. Contrary to the advocate's marketing advertisement rules, the advocate should take care also that the appearance and comments he or she makes do not infringe on the advocate's obligations to the client, the profession, or the courts. So before I did an analysis of SOPPEC number 2. Remember that advertisement is not banned in Kenya because what is prohibited is touting or solicitation or advertising that fall outside the permitted context of the marketing and advertising rules. Because a total ban was held unconstitutional. That is a potential oral question. Total ban on advocate advertising was held. The High Court held that rule number 2 of the advocate practice rules, to the extent it imposed a complete ban on advertising, was inconsistent with the constitutional consumer and access to justice guarantees. So, do you know the rationale why it was held unconstitutional? It was inconsistent with the constitutional consumer and access to justice guarantees. Then what remains prohibited? What remains prohibited is touting or procuring instructions through paid runners or other inducement solicitations targeted by statute. Remember I said Section 38 prohibits touts of the Advocate Act. Another rationale that we can borrow from SOPPEC number 2 is that we are preventing what we call undercuttings. Because if people are to advertise, they will even go to the extent of undercutting. Okay? Undercutting is the willing to do work below prescribed remuneration. The RO provides for below minimum, but you are allowed to go higher, but the same should be reasonable and justifiable. That's why you can be taxed. Permitted advertising is governed by the advocate's marketing and advertising rules. I'm looking for where students go wrong. Students usually go wrong when they say that advertising is absolutely prohibited, because that shows you don't know the current affairs of that development. Let's go to SOPPEC number 3. SOPPEC number 3 test for competence and diligence in handling a client's brief. An advocate is under a duty. Let me project SOPPEC number 3 from my screen. SOPPEC number 5. SOPPEC number 12. SOPPEC 2. SOPPEC number 3. An advocate is under a duty to provide the legal services in respect to which he or she is engaged competently, diligently, and ethically, and failure to do so will be dealt with as professional misconduct. So the standard on competence comprises several elements. Okay? This is where the examiner tells you that I need to see your interpretation of SOPPEC number 3 through a problem question. Can you extract the elements that form competence and diligence in handling a client's brief? 1. Qualification to be admitted as an advocate is a standard, is an element on its own. Qualification to practice law, because it shows competence and diligence. Possession of knowledge, skills, and competence to undertake the brief at hand. If you don't have the necessary competence and diligence or skills, the Cabranc rules provides an exception to that you can refer a matter from you to another advocate on grounds that you don't have the required knowledge and skills and competence. So if you take a matter and you don't exercise the exceptions provided by the Cabranc rule, that means you will be subjected to SOPPEC number 3. D, diligence in the conduct of the brief, and E, client care, and F, professional indemnity cover. An advocate decides to practice without taking out a professional indemnity cover from an insurance, and the minimum is 1 million. Okay? So failure to take that from the facts given to you automatically means that you are infringing, you are breaching one of the elements in SOPPEC number 3. What is the rationale? The examiner loves this question. A client is entitled to assume that by virtue of being licensed to practice law, the advocate has the knowledge, skills, and competence required to deal adequately with a client's brief, and they are not wrong because you had the opportunity to tell them that you don't have the necessary skills. Competence involves possession of an understanding of legal principles, as well as adequate knowledge of the practice and procedures by which legal principles can be effectively applied. This advocate should be reading out decisions. Okay? Competence also requires effective client care and office administration and management strategies. This is the reason why you're being taught LPM, because failure to follow office administration and management strategies, you will end up violating SOPPEC number 3 on client care. Okay? So those are 3 rationales. Okay? Client care. Then the client expects that you know about legal principles, and that the client assumes that by the fact you are licensed, you have the capacity to handle his brief. SOPPEC number 3 still proceeds to tell us that there is a constitutional basis for the standard. Because if you read Article 46(1) of the Constitution, it confers on consumer rights. Okay? It confers the consumers the right to services of reasonable quality, not just services, reasonable quality. So SOPPEC number 3 came to say that the standards of an advocate should be competent and diligent. Okay? So clients, being consumers of legal services, they have a constitutional right to quality legal services. Therefore, if you breach SOPPEC number 3, you are also breaching the Constitution. Remember, we have what we call the continuing professional development rules, the advocate's continuing professional development rules, that requires and makes mandatory attendance of continuing professional development programs on an annual basis. Okay. Qualification to practice law is also tested pursuant by Section 13 of the Advocates Act, where the advocate's degree qualifications regulations and the advocate's admission regulations prescribe the professional and academic qualifications required for admission as an advocate. They went ahead to separate admission requirements through regulations and even degree qualification regulations on their own to make sure that when you are approaching SOPPEC number 3, you have necessary qualifications, because qualification to practice law was one of the elements that forms the basis of SOPPEC number 3. Okay? What if an advocate fails to comply with the CPD regulations? That is an act of professional misconduct directly written and captured in SOPPEC number 3. Okay? What is the rationale? The rationale is that following an admission, an advocate is assumed to be legally qualified to handle any brief on account of limited experience and the specialist nature of certain kinds of legal issues. An advocate may not well not have the competence to undertake specific kinds of work. It is not good professional practice for an advocate to accept instructions in respect to which he or she has no capacity to carry out competently on account of either the specialist or complex nature of the brief or the experience of the advocate. Okay, and you are allowed to inform the client of the fact that the advocate cannot on his or her own carry it out, and the event that the client chooses to proceed and instruct the advocate should, following discussions with the client, make appropriate arrangements for the work to be undertaken by or in association with an advocate with the appropriate skills and capacity to competently carry out the work. And as a general principle, you as the advocate, you should advise the client of the need for specialist input where the matter is complex or relates to a specialist area of legal practice. Because failure to do so poses the risk of adversely affecting the client's interest, and should that lead to a complaint from an aggrieved client, the advocate risks discipline for professional misconduct. In addition, the advocates risk liability for professional negligence. So we can say failure to tell a client to choose a specialist in the legal matter that the client has posted before you, it can amount to a professional misconduct and a risk for professional negligence. Okay? What does the SOPPEC try to tell us about diligence? It tells us that the advocate has an obligation to carry out the work given to him by a client in a diligent and timely manner. Okay. Integral to the competent provision of services to a client is proper office management and administration systems. This is where the SOPPEC rule now decides to tell us about the client care element forming part of the SOPPEC number 3. Because the advocate is under an obligation to put in place a client care system to enable the advocate manage the client diligently. Failure to put in place and operate a client care system can lead to a finding of professional misconduct. And what are the examples which might lead to disciplinary action for professional misconduct arising specifically from SOPPEC number 3? Failure to keep the client periodically informed about developments affecting the client's matter. That will land you to a professional misconduct complaint. Treating the client discourteously or despectively by, for example, showing rudeness or routinely failing to keep appointments with the client without prior information to the client. Being rude and disrespectful by cancelling appointments. That is a professional misconduct from SOPPEC number 3. Writing letters that are abusive, offensive, or rude, or totally inconsistent with the proper tone of professional communication from an advocate. You can be told there is an advocate going around making social media limelights focused on him, telling you that, oh, this is how I'm supposed to write letters, and if you read that letter, it's very abusive and offensive, or rude, or totally inconsistent with the proper tone of professional communication from an advocate. That advocate will risk a professional misconduct complaint. Another angle. Failing to take action on a client's matter when such action is needed for the effective management of the case. Okay, so this is where the rules are prohibiting an advocate from prosecuting a case for more than 1 year as required by the rules. Another element, another standard, manifestly poor quality work or a pattern of poor quality work with obvious errors of fact and or law, such as poorly drafted pleadings, will amount to a professional misconduct. And failure to maintain a system for addressing and remedying client grievances. If clients usually complain but you never take action, that will amount to a professional misconduct. Okay. The SOPPEC number 3 is also important because it continues to tell us that upon discharge or withdrawal from acting in a matter, you as the advocate, you should deliver to the client all papers and property belonging to the client and provide the client all material information about the case. and account for all funds of the client and refund any remuneration not earned by virtue of the services being rendered, and cooperate with the successor advocates to enable them take over the case or instruction. So whenever you see fact that a certain advocate finished to act on behalf of a client, then another advocate tries to request for these documents and the previous advocate is declining to provide for the same, this is a risk pursuant to SOPPEC number 3. Okay. Then it is good practice that you should confirm that the previous advocate or the successor is in good terms with the client, or in that there are no debts, so that you should seek consent from the former advocate through if the matter is post-judgment. So to avoid a situation where the client is hopping from one advocate to another, leaving out bills and unpaid legal fees. Okay, so that is also provided under SOPPEC number 3. Then remember I told you that one of the elements forming this SOPPEC number 3 is professional indemnity cover, and there is the Advocates Professional Indemnity Regulations of 2004 imposed a requirement for a professional indemnity cover to be purchased by every advocate practicing on his own behalf. And the essence of this cover is to compensate clients for loss or damage from claims in respect of any civil liability or breach of trust by the advocate or his employees. Okay. And under the rules, it continues to tell us that the Advocate Professional Indemnity Regulations rules says that no practicing certificate shall be issued to an advocate without evidence of the required amount of professional indemnity insurance cover. And any advocate who proceeds to engage in practice without maintaining the required level of professional indemnity insurance can face disciplinary action for professional misconduct. So that is what is being provided by SOPPEC number 3, competence and diligence. Let us move to SOPPEC number 4. But before I do so, this is where many students will face a challenge. They don't interpret the SOPPECs. So what I did through, as per the screen before you, is that I interpreted it through courts. So courts treat as competence and diligence pursuant to SOPPEC number 3 as a concrete, enforceable duty arising from the retainer. An advocate must exercise ordinary reasonable skill and care and must not miss basic procedural and limitation steps. Where the lapse is on elementary matters, courts readily find professional negligence and or uphold discipline. So this is where you will retrieve the test for this SOPPEC. Okay, and to be brief, let me take you directly to the various tests that are being applicable in a professional negligence element, a question that usually finds itself in many professional ethics papers. You should be in a position to prove there is a duty, okay, there is a retainer or instruction from an advocate to a client, or the advocate-client relationships can be inferred through conduct or in writing. Then there is a breach of that duty. So this is where you fail to exercise reasonable care or skill, e.g. missing limitation of time. So there is a breach. Then there is a concession and there is a loss. Client loses the claim or opportunity to appeal. Okay, and typical scenario is where the examiner will tell you that a client gives written instructions to sue, advocate sits on the file, limitation lapses, client's underlying cause become irrecoverable, advocates will be held liable. And another key distinction that I wanted to portray is that we have elementary procedural law mistakes. What are these? E.g. defective affidavits will be gross negligence. If you read the case of National Bank of Kenya versus E. Murio Kamau 209, the ratio decided was that advocates owe a contractual and tortious duty to prepare and file competent pleadings and comply with basic affidavit requirements. Non-compliance with an elementary requirement and failure to cure after being alerted amounts to professional negligence. So the examiner at times will give you situations where they want to test you, whether you know the difference between a professional negligence and a professional misconduct arising from the facts. And if the examiner appears to be testing you on elementary procedures of the law, just know that they want to test you on the elements that I've outlined for negligence. So generally, the principle of how courts separate mistake from negligence is that liability attaches for gross negligence or ignorance of elementary matters of law constantly arising in practice, not for every reasonable judgment. And typical scenarios where the suit is struck out because verifying affidavit is improperly commissioned, advocates ignores notice to rectify, client suffers judgment and cost, and the advocate will be held liable. So that is one example where negligence is inferred. Then an advocate must act with reasonable skill and diligence, including proper cessation of acting and keeping the client informed of hearing dates and steps. Failure to notify and manage withdrawal properly can deprive the client of a defense and attract liability. So the same negligence elements will be tested throughout when you want to find an advocate to have breached professional negligence. So those are the tests that I wanted to portray before you. And there is a deeper interpretation of this test for you to understand is that when you want to establish a standard of care where we have gross negligence versus error of judgment test, did the advocate fall below the standard of a reasonably competent advocate? Because courts draw a sharp line, because not every error is negligent or attaches a liability for gross negligence or ignorance of elementary matters of law. Okay, so there is a test that is being provided, and the test mechanism is applied to a reasonably competent advocate. Then what are elementary procedural compliance tests? How will you identify it? Was the mistake on a basic, constantly arising procedural requirement that competent advocates are expected to know and comply with? Is it touching affidavits, pleading validity requirements? If yes, courts readily label it gross negligence. Okay. So those are the things that an advocate, the examiner will be requiring you to have grasped before answering that question. Then we are going to SOPPEC number 4. I believe I saw SOPPEC number 4. So I believe now you can be in a position to now appreciate how I mix research, how I mix verbatim interpretation of these provisions. SOPPEC number 4 tells us on professional fees. And SOPPEC number 4 is categorical that the practice of undercutting, that is charging less than the scale fees for professional services rendered, constitutes a professional misconduct. Similarly, unjustifiably high fees, which is not commensurate with the professional services rendered, constitute professional misconduct. So the examiner will test you that there is an advocate who has charged way above the required RO. So they know that the RO provides for the minimum. But there is a situation where the advocate has charged professional fees to the skies. So if it is not commensurate with the professional services being rendered, that constitutes a professional misconduct. And what is the statutory basis? The statutory basis is the advocate's remuneration order. Because Rule 3 of the same states that no advocate may hold himself out or allow himself to be held out directly or indirectly as being prepared to do professional business at less than the scales laid down by the advocate's remuneration order for the time being in force. What is the rationale for this standard? It is misunderstanding about fees and failure to adhere to the provisions of the advocate's remuneration order is a common cause of complaints against advocates. The perception by a client that the fees charged are inflated or that the advocate seeks to take advantage of the client will undermine the client's confidence in the professionalism and integrity of the advocate. If such undercutting widespread, it poses the risk of bringing the legal profession into disrepute and undermining the administration of justice. So key takeaways as the rationales why we have this SOPPEC number 4. Perception from the client. The client's confidence will be lowered. The profession itself will suffer disrepute, and it will undermine the administration of justice. Those are the marking points that the examiner will be looking at. Okay? It is good professional practice for advocates to always encourage clients to issue written instructions before the advocate's engagement commences. Why? Because written instructions may take the form of either a letter of instruction issued by the client or a memorandum of agreement. It is a professional misconduct for an advocate to undercut by charging fees below the scale fees stipulated by the RO. This prohibition means that an advocate who participates in a tender process by bidding for work may not, in his or her financial bid, quote fees below the scale fees. Neither may an advocate enter into an arrangement with a client for discounts based on volume as a consideration for being retained to undertake the work or some other basis if such retainer will breach the remuneration order. At times you will encounter yourself applying for tenders, and maybe the tender says the amount with the lowest bidder will carry the day. But for advocates, that is different, because you, in as much as you can bid any amount, you can't bid below the remuneration order. So this is in tandem with SOPPEC number 4 on professional fees. Okay. And in cases, so SOPPEC number 4 continues to tell us that in cases of indigence or hardship faced by a client, or where the matter in issue is a public benefit matter or the organization in question pursues charitable objectives, advocates are encouraged to agree to provide legal services on a pro bono basis, in which case no fees are chargeable. Okay. Where, however, instead of undertaking the work pro bono, the advocate wishes to reduce the amount of fees chargeable below the scale fees on account of hardship or poverty of the client, or in the case of a client which is a charitable organization, as a contribution to the charitable cause being advanced by the client, the prior written permission of the regulation bodies, regulatory bodies such as the society, shall be obtained. So you can encounter a situation where the client says that they are poor, or you are in a situation where it is a charitable organization. You should write to the society requesting for their permission. Where, however, the society has issued guidance on the charging or waiver of fees for work undertaking pro bono or at a discount, the advocate shall take account of and give effect to such guidance. Failure to do so will be a ground for disciplinary action. What does SOPPEC number 4 talk about when it comes to overcharging? The fees prescribed in the advocate's remuneration order are minimum scale fees, not a cap. The remuneration order also allows fees to be based on agreement between an advocate and the client. However, to inflate fees unjustifiably, particularly in respect of vulnerable clients, can undermine confidence in the professionalism and integrity of the advocate. It can also undermine confidence in the legal profession. Examiner will expect to see whether you know what amounts to overcharging. Overcharging amounts to inflating fees or disbursements to be incurred, misleading the client so as to the scale fees, generating unnecessary work as a basis for extra fees, misrepresenting the amount or the complexity of the work being involved, claiming that the work took more time to carry out than it did, and so on. So the SOPPEC number 4 has contemplated that there are instances where an advocate can try to be mischievous. And if you try to be mischievous, SOPPEC number 4 will catch up with you. Then SOPPEC number 4 continues to tell us that contingency fees are not permittable. Okay? These were the advocate fees or a portion of it is pegged on the outcome of the case. This is prohibited because the law prohibits championship, which is an arrangement to divide litigation proceeds between the owner of the litigated claim and a third party to the lawsuit who supports or helps to enforce the claim. Okay. Championship is prohibited in any case, but as regards advocate, it is prohibited also because an advocate who has a financial interest in the outcome of the case is unlikely to provide objective advice and disinterested service to the client. That is the rationale why championship is prohibited. You can even you can be also involved in corruption because you have a financial interest in the outcome of the case. Okay. And the prohibition of championship extends to any arrangement under which the advocate acquires a financial or other proprietary interest in the subject matter of the dispute or in the outcome of the case. And the reason for this prohibition is interesting because it continues to tell us that the risk of conflict arising which would undermine the advocate's ability to render objective legal service and services advice to the client. Advocates should therefore ordinarily avoid the temptation because the rationale from the prohibition of championship is to avoid a conflict of interest arising or a conflict generally to provide objective legal advice. And advocates should also avoid a situation in which the advocate effectively becomes a creditor of the client by financing the litigation or the pursuit of a claim on the understanding that the advocate will recover the money advanced for the proceeds of the settlement. Okay? Because this requires the approval of the society. And in all situations, such agreements should be in writing. So this rule continues to tell us that the advocate should also avoid entering into an arrangement under which the client settles legal fees in kind through, for instance, the rendering by the client of services to the advocate or the transfer by the client to the advocate of property in settlement of legal fees. Such arrangements involve various legal and technical complications, including how to value the services or property provided by the client, the payment of income and value-added tax by the advocate, and risk that the advocate-client relationship gives way to a transferee-transferor relationship with all its attendant complications. So you are not allowed to settle legal fees in kind. This is why you have properties settlements in exchange of legal fees. Then also the rule prohibits sharing profits with an unqualified person because it extends the practice of paying a commission to or sharing fees with another person for introducing work or referring clients. This is also in quotes called finder's fee. It also promotes unethical conduct and corrupt practices which undermine the standing of the legal profession. It constitutes professional misconduct and will expose the advocate to disciplinary action. Remember, if you read the previous past papers, the examiner usually loved this angle. In fact, it was asked in Professional Ethics 2025 that a certain advocate was paying commissions. So the examiner expected to see a student who understood the prohibitions outlined in SOPPEC number 4 on professional fees. That is how deeper this interpretation goes. Okay. So before we go to SOPPEC number 5, let us read what I have prepared before you. So Kenyan courts treat advocate fees in SOPPEC 4 as a regulated space. You may contract on fees only within the Advocates Act or remuneration framework. Undercutting the law or exorbitantly is a misconduct. Contingency and championship has also been observed, and SOPPEC number 4 is to be read with section 36 of the Advocates Act on undercuttings. In section 37 on sharing of profits with unqualified person, and touting pursuant to section 38, where SOPPEC number 4 directly states on finder fees or commissions. Then SOPPEC number 4 also talks about the advocate's remuneration order and about invalid arrangements between an advocate and a client. This one I can explain because section 45 and 46 of the Advocates Act has defined that there are some agreements between an advocate and a client that can be rendered invalid, and in particular where an agreement charges way below the remuneration order, that will be an invalid agreement. Because an advocate-client fee agreement must meet section 45(1) on formalities. Okay, it should be written and signed by the client. Even if proved, an agreement that effectively results in fees below prescribed scale offends the Act pursuant to section 46 and is invalid and unenforceable. Okay. So before you can take note of the various decisions, because I don't see a situation where I will reiterate this part because it is a straightforward part. Let us move to SOPPEC number 5. SOPPEC number 5 tells us on client's property. The advocate shall not appropriate or convert any funds of the client held in trust or otherwise under the advocate's control without the express authority of the client. Any unauthorized appropriation or conversion shall be treated as professional misconduct. And the rule continues to tell us that there is a statutory basis for this standard. And the statutory basis is where the advocate violates the advocate's account rules, and we have the advocate's accountant certificates rules and the advocate deposit interest rules. So all those rules have been created in support of the client's property pursuant to SOPPEC number 5. The fiduciary duty and rules also apply to client's property, where property includes securities such as title deeds, charge documents, share certificates, wills, files, original documents, and so on. And therefore, you as an advocate, you have a duty to maintain a record of the client's property. This is why you are being taught about record keeping in LPM, legal practice management, so that you can't violate SOPPEC number 5. And what are the pillars of the advocate's fiduciary and statutory duties towards the client? The pillars are to keep client's funds separate from the advocate's own monies and avoid commingling of funds. B. Faithfully account to the client for any use made of the funds on the client's instructions for disbursements and other purposes. And C. Promptly pay out to the client any money belonging to the client. And D. Safeguard other client's property in his or her possession to prevent loss, damage, or unauthorized access and or use. The examiner is interested in whether you know the rationale for this standard, because complaints arising from misappropriation or conversion of a client funds usually constitute the majority of complaints for professional misconduct lodged against advocate. Okay, because this complaints not only does such conduct undermine confidence in the legal profession as a whole, but it also undermines the administration of justice. And improper handling of the client's funds contrary to the standard will be dealt with as a professional misconduct. And what are the other acts that have been laid down by SOPPEC number 5 that will expose the advocate to risk of disciplinary actions for professional misconduct? We have 1. Issuing a check drawn on client's account which is dishonored for lack of funds. B. Failure to produce an accountant's certificate or statutory declaration pursuant to the accountant's certificate rules. Failure to maintain a separate client's account and evidence of commingling of funds or use of client funds to finance office, business, or personal expenses. So the examiner can coin a situation that meets the threshold for these tests. Trading with client's money through, for instance, delaying payment of the funds to the client to enable the advocate earn interest on the money contrary to the advocate's deposit interest rules. So the examiner expects a student to have read the advocate's deposit interest rules. The examiner expects the student to have read the accountant certificate rules. And you being a student and you have not analyzed the SOPPEC rules, you will be exposed to such situations because you will not know this is prohibited. Because you'll think this is just a story. You'll be told the advocate withheld this money, delayed this money, and instead decided to invest the same in a joint earning interest account. You have mixed, you have mingled, you have issued a check that has bounced to, that has been dishonored to the client. Okay? Your office does not have accountant certificates whenever you are using or revealing your financial statements. Okay? As a general rule, an advocate may legitimately not reveal information about a client's funds or other property to third parties without the client's authorization. It is of great importance why we are analyzing the SOPPEC rules this way. And one advocate who knowingly or abates money laundering or other financial crimes is guilty of professional misconduct and risks losing the protection accorded to the advocate as regards client information. Because you should be guided by the Proceeds of Crime and Anti-Money Laundering Act as an advocate. Therefore, it is good practice for the advocate to put in place systems and measures to safeguard against the use of the client account for money laundering or other illegal transactions, such as know your client measures. And the examiner can tell you to give various measures that an advocate can impose to make section SOPPEC number 5 operational. Ascertaining the identity and authority of the persons transferring funds into the advocate's account and the legitimacy and purpose of the funds transfer. Identity and the purpose. B. Maintaining complete records of funds received from clients and third parties. Do you have records? Where there is reason to do so, making appropriate inquiries of the client and third parties as to the source or origin of the funds. Declining instructions where there is reasonable cause for concern that acting on the client's instruction will lead to possible contravention of the law against money laundering. So this is an exception to the cab-rank rule. SOPPEC number 5 can be an exception. Okay. Let us move forward to see what I had managed to capture. So generally, you should read Section 80 of the Advocates Act that criminalizes betrayal of trust by an advocate entrusted with money or property. So the examiner will expect to see whether you know the penalty that is provided under Section 80, where the advocate betrays trust. Section 80 is a criminal offense. In professional misconduct plus sanctions, we have admonition, suspension, striking off, you can be given fines, compensation. This is pursuant to Section 16. And we have court's remedy to compel cash account, delivery of money and securities, list of properties, and delivery of documents pursuant to Order 52 Rule 4 of the Civil Procedure Rules. The client can make this application before the court. Okay. Privilege does not protect communications in furtherance of illegal activities or crime or fraud. This is pursuant to Section 134 of the Advocate Act. And POCAMLA Act, Proceeds of Anti-Money Laundering Claim. Proceeds of Crime and Anti-Money Laundering Act, Section 18. Advocate-client privilege qualified by court order in investigations. This in particular says that the court can give an order to investigate into an advocate, but that order is still confined in that the advocate-client privilege is qualified. So those are the enabling provisions that give rise to SOPPEC number 5. So I believe up to that point, I have exclusively given you the various threshold for you to analyze and read for yourself. because we are now going to SOPPEC number 6, conflict of interest. Conflict of interest is directly provided by SOPPEC number 6, where it tells us that the advocate shall not advise or represent both sides of a dispute and shall not act or continue to act in a matter where there is a conflicting interest unless he or she makes adequate disclosure to both clients and obtains their consent. So we can say that consent and disclosure is an exception. Okay. This is SOPPEC number 6. What is the rationale for this standard? The advocate's ability to present the client may be materially and adversely affected unless the advocate's judgment and freedom of action are as free as possible from compromising influences, and the relationship between the advocate and the client is not materially impaired by the advocate acting against the client in any other matter. Another rationale is that maintaining loyalty to clients promotes trust and confidence in the advocate. Therefore, as a general rule, an advocate should not knowingly assume or remain in a position in which a client's interests conflict with the interest of the advocate, the firms, or another client. The advocate should not represent a client if the representation involves a conflict of interest. What are the situations that a conflict of interest can arise? That has been captured pursuant to SOPPEC number 6 of the SOPPEC rules, where the interests of one client are directly adverse to those of another client being represented by the advocate or the firm. For instance, in situations where the representation involves the assertion of a claim by one client against the other. That is situation number 1. 2. Where the nature or scope of representation of one client will be materially limited by the advocate's responsibilities to another client, a former client, a third person, or by the personal interest of the advocate. Okay? Where the nature or scope of representation of one client will be materially limited by the advocate's responsibilities to another client, even a former client, even a third person, or to the personal interest of the advocate himself. Where in the course of representing a client, there is a risk of using wittingly or unwittingly information obtained from a current or former client to the disadvantage of that other client or former client. So there is a risk of using information being obtained from a current or former client. Additionally, a client is entitled to expect independent, unbiased, and honest advice from an advocate. In circumstances in which advocate's independence may be at risk of being compromised will include the following. Where the advocate is being involved in a business transaction with the client, such as a debtor-creditor relationship, that is prohibited. And it is a likelihood that that circumstance will lead to a conflict. Acquiring an ownership, possession, or security interest in a property which is adverse to the client's interest in the same property. That is also another angle where an examiner can test you on. And C, acquiring a financial interest in the subject matter of the case that the advocate is handling. You have went ahead to obtain a financial interest in the subject matter of the case you are handling. That is a ground for conflict of interest. Having a personal or professional relationship with the adverse party or a close associate or family member of the adverse party. A conflict of interest. Okay? Remember, the standard applies to advocates in practice as it does to in-house counsels, notwithstanding that in later case the advice is rendered to the employer. The objectivity and detachment of an in-house counsel may, however, be compromised, understandably so, by the employer-employee relationship. And generally, as a good practice, you are required to make a full and frank disclosure to the client when it becomes clear to the advocate that there is a conflict of interest. This requirement is to enable the client to make an informed decision about whether to have the advocate act despite the existence or possibility of a conflicting interest. The advocate should, however, nevertheless guard against acting for more than one client where, despite the fact that all parties concerned consent, it is clear that a contentious issue may arise between them or that their interest, rights, or obligations will diverge as the matter progresses. So it is not cast on stone that once you have obtained a consent, you are out from the confines of SOPPEC number 6. We have seen an exception where there are more than two, more than one client, and the circumstances or issues surrounding that case will be contentious. As the matter progresses, you will not be spared. And further, an advocate who has acted for a client should not, in the same or a related matter, act against the client or otherwise act against the client where the advocate might be at risk of using against the client information previously obtained from the client. It is not, however, improper for the advocate to act against the former client in a fresh and independent matter, wholly unrelated to any work the advocate has previously done for that person. That is an exception. It is not, however, improper for the advocate to act against the former client in a fresh and independent matter, wholly unrelated to any work the advocate has previously done for that person. That is an exception. Because the advocate may act in a matter which is adverse to the interest of a current client, provided that the matter is unrelated to any matter in which the advocate is acting for the current client and no conflicting interest is present. Then lastly, accepting instructions and proceeding to act without making a disclosure of the existence of a conflict of interest amounts to professional misconduct, because it will be good practice for the advocate to ensure that the disclosure made and the client's decision that the advocate should continue to act despite the existence of a conflict of interest are both in writing. It is not oral, it should be in writing. What did I capture? Person to SOPPEC number 6. The courts will bar an advocate for conflict of interest, person to SOPPEC number 6, where the applicant proves 1. That a prior or current advocate-client relationship and a real risk of prejudice or misuse of confidential information, where we have real mischief or real prejudice, because mere suspicion or prior contact or having drafted common documents will not be enough. What are the governing rules? We have Section 6 of the Advocates Act that will form the disciplinary basis of this professional misconduct. Section 55 of the Advocates Act and Section 56 of the Advocate Act tells us that the advocates are officers of the court and subject to court's control for misconduct in proceedings. And Section 134 of the Evidence Act talks on privilege of advocates. Confidentiality or privilege survives the retainer. It is important because courts won't force a former client to reveal the secrets to prove conflict. Okay? So Section 134 is also important in SOPPEC number 6, because you have been told that conflict, or privilege will survive the retainer. This is important because courts won't force a former client to reveal secrets to prove a conflict. What are the tests? The core disqualification test is real mischief or real prejudice plus confidential information risk. This is a landmark decision known as Century Oil Trading Company Limited versus Kenya Shell Limited 208, where the ratio decided was that an advocate who previously acted for a party in related matters may be disqualified if there is a real risk or reasonable perception that confidential information obtained in the earlier retainer could be used to the former client's detriment, because the duty of confidentiality survives the retainer. And the test that was laid out in this decision: does the advocate possess confidential information relevant to the new matter, and is there a real risk of misuse? Okay. Then we have another decision known as in Real Estate of Wamatu Wanguku, 2019. Ratio decidendi was that where a firm previously acted for an applicant in the same succession cause and later appears for protesters adverse to that applicant, the risk of confidential information being used wittingly or unwittingly is real and substantial. Counsel of choice yields to protecting confidentiality and integrity of the process. And the test that was applied in this case was that prior representation, where the matter was involved same or closely related subject matters, and there was a real risk of prejudice, then the advocate ought to disqualify himself. Then mediation or third-party role can create former client confidential information conflict. Because if you read the case of Dinga versus Saida 2025, even where an advocate denies formal retainer, participation in mediation or due diligence that exposes the advocate to both parties' confidential information can create a real or perceived conflict. The court barred the advocate from acting to protect confidentiality and fairness. And there are situations where courts refuse to disqualify, where during drafting or witnessing agreements exchanged between both parties does not automatically create confidential information without evidence of real mischief or prejudice, and therefore disqualification of the advocate was refused. Because you must show more than prior involvement. An applicant must show more than prior involvement, must show confidential information relevant to the present dispute and real risk of misuse. So generally, SOPPEC 6 is to be approached with caution. This is the reason why I'm reading the test that you should apply. Current client conflict, where the advocate acts for both sides. The rule in practice is that for both sides in a dispute is almost always fatal because loyalty is split. Consent helps only where interests are aligned and remain non-contentious. Once contentious issues arise, you should cease acting for one or both. We have seen the direct interpretation of it in SOPPEC number 6 that you will not be spared. Then B, what about former clients' conflict? This is mostly litigated. Courts apply a functional test. And the test that the court will lay before it is 1. Was there a prior advocate-client relationship? If the answer is yes, can we see the instructions? What is the advice? Was there a mediation role? Was there handling documents that were in confidence? 2. Is the new matter the same or sufficiently related? Do you have the same assets, same transaction, same dispute family? Then 3. Is there a real risk of prejudice or misuse of the confidential information? Then 4. Balance against counsel of choice. But the balance usually favors confidentiality where real risk is real, person to the century oil decision. Then you have situations where there is a personal interest conflict. If the advocate's own interest materially limit independent advice, disclosure plus consent may not cure it, where the advocate's judgment is objectively compromised. So those are the various situations that I wanted to bring out in clarity. Okay. Conflict, don't assume that consent always cure conflict. Students, don't structure the answer as a test. You will rush to give an answer, but the examiner wants to see a relationship existed, relatedness of the matter or the issues, confidential information was at risk, and there was real mischief and prejudice, and then what is the remedy? That is what the examiner will mark. The examiners are practicing advocates, and they know exactly what happens in practice. SOPPEC number 7. SOPPEC number 7 tells us that confidentiality of advocate-client communication. I'm looking for the interpretation of it. I did not have time to arrange them in a numerical order because that could have spared a lot of cross-referencing. SOPPEC 5, SOPPEC 7. Good. Communication between the advocate and the client is protected by the rule on confidentiality of advocate-client communication. What is the rationale? The protection accorded to communication between the advocate and the client and advice given by the advocate to the client through the doctrine of professional privilege is a critical element of public trust and confidence in the administration of justice and the independence of the legal profession. The advocate cannot render effective professional service to the client unless there is full and unreserved communication between them. So the client is entitled to assume that without his express consent or otherwise required by law, matters disclosed to or discussed with the advocate will be held in secrecy and confidentiality. SOPPEC 7 continues to tell us that we have a statutory basis for this. Section 134(1) of the Evidence Act directly prohibits advocates from disclosing privileged advocate-client communication, because the privilege covers contents and conditions of documents within the advocate's knowledge as well as advice rendered by the advocate to the client. And Section 134(2) of the Evidence Act proceeds to extend the obligation for non-disclosure after employment of the advocate has ceased. Under Section 134(1), an advocate is only permitted to disclose privileged communication with the express consent of the client. However, Section 134(1)(a) and (b) does not protect communication made in furtherance of an illegal purpose, as well as observation by the advocate on commission of crime or fraud from the time of his employment as the client's advocate. Section 135 continues to tell us that it extends the duty for non-disclosure of privileged information to the clerks and servants of the advocate. Okay. The duty of confidentiality may be waived by the client, and therefore, if a situation arises in which an advocate is called upon to disclose such information, and it is not a situation in which their duty has been exempted or qualified by law, before making the disclosure, the advocate should seek the consent of the client, preferably in writing. Okay. The scope of the principle of confidentiality is greater than that of the legal professional privilege. Because the advocate's obligation of confidentiality and professional secrecy extends beyond the period of subsistence of advocate-client relationship, because it has no time limit. And another key takeaway is that the advocate-client communication also applies to the support staff in the advocate's office. The exceptions are that there are situations in which the principles of confidentiality and professional secrecy do not apply, as we have read directly. So basically, this is a straightforward interpretation, and basically as a student you should be in a position to extract out the exceptions, because the examiner can be testing on exceptions. Okay. Have you obtained consent, or the waiver has been obtained? Is it in a furtherance of an illegal activity? Okay. Is it an observation that you have made on commission of crime or fraud from the time of employment? That will not be an exception. That will not be protected, because you are aware and you saw it, you observed, and you never disclose the same to the society or investigating bodies. Okay. Lastly, let us talk on SOPPEC number 8. SOPPEC number 8, let me project the same from my slides. Basically, SOPPEC number 8 tells us about fidelity to the law and due process. The advocate is an officer of the court, and therefore the advocate shall discharge his or her duty to represent the client in adversarial proceedings and non-contentious proceedings by fair and honorable means and without illegality or subversion of the due process of the law. What is the statutory basis for this standard? Section 55 of the Advocates Act is the statutory backing, because it identifies advocates as officers of the court. Hence, advocates are subject to the jurisdiction of the court, the Advocates Complaints Commission, and the Advocates Disciplinary Tribunal. Section 55, fidelity to the law and due process. Rule number 8 of the Advocates Practice Rules makes certain provisions for the advocate's conduct in the context of adversarial litigation. The rule prohibits the advocates from doing the following. The Advocates Practice Rule number 8 prohibits you from appearing as a witness before any court or tribunal in a matter in which he has reason to believe that he may be required as a witness to give evidence. You are prohibited. You are prohibited from coaching or permitting the coaching of any witness in the evidence he will give before any court, tribunal, or arbitrator. You are also prohibited in calling to give evidence before any court, tribunal, or arbitrator any witness whom he knows to have been coached in evidence without first informing the court, tribunal, or arbitrator of the full circumstances. Because in adversarial proceedings, the advocate's function as an advocate is necessarily partisan, and you don't have any obligation to assist an adversary or advance matters which undermine the client's case. Okay. And SOPPEC number 8 continues to tell us that the advocate shall not resort to illegal or unlawful means as sharp practice to advance his client's case. Examples of conduct which will amount to professional misconduct in the context of court or tribunal proceedings are as follows. 1. Abuse the process of the tribunal by instituting or prosecuting proceedings or applications that, although legal in themselves, are motivated by malice on the part of the client or are brought solely for the purpose of injuring the other party or frustrating the processes of the court or arbitral tribunal. And B. Knowingly perverting or frustrating the cause of justice by assisting or permitting the client to do something which the advocate considers to be dishonest or unlawful, such as procuring the disappearance of court files or removal of documents from the court records. C. Conducting a matter before a judicial officer when the advocate or client has a business, personal, or other relationship with such officer that gives rise to real or apparent pressure, influence, or inducement affecting the partiality of such judicial officer. And D. Attempting or allowing another person to attempt to influence the decision or actions of the judicial officer through corrupt or other unlawful means. E. Knowingly deceiving or participating in the deception of a judicial officer or tribunal by offering false evidence, misrepresenting the facts or law, presenting or relying on a false affidavit or other evidence, suppressing, relevant, or assisting in any fraud, crime, or illegal conduct. And lastly, dissuading a material witness from giving evidence or to falsify evidence. Okay. That is what is provided by SOPPEC number 8, fidelity to the law and due process, and in particular I want you to carry the great SOPPEC, the great section 55 of the Advocates Act, the duty as an officer of the court. Then you go to SOPPEC number 9 on professional undertakings. For professional undertaking, I believe I had discussed on the same. Professional undertaking. The advocate is under a duty to honor any professional undertaking given in the course of his or her practice in a timely manner. Failure to honor the same is a professional misconduct, and an undertaking is a formal promise whose effect is to make the person giving it responsible for the fulfillment of the obligations in respect to which it is given. An advocate's undertaking is a personal promise as well as a professional and legal obligation. It is based on the concept of the legal profession as an honorable profession and the expectation that an honorable person will honor his or her word. What is the rationale for this standard? The effectiveness of undertakings given by the advocate depends on the confidence and belief that a party has that reliance can be placed on the undertaking. The advocate's failure to honor the undertaking undermines such confidence and is detrimental to the client's interest. Moreover, a breach of a personal undertaking adversely affects the advocate's reputation as well as the reputation and trustworthiness of the legal profession as a whole and potentially can jeopardize legal transactions. So, in brief, what are the rationales? Detrimental to the client's interest, damaging to the reputation, and jeopardizing legal transactions. A professional undertaking is enforceable against the advocate personally, and therefore the advocate must exercise care when giving and accepting an undertaking. Care requires that the advocate observe the following principles in giving an undertaking. You should obtain the client's express authority to give it. Give the undertaking in writing, and where given verbally, reduce the same into writing as soon as reasonably practicable thereafter to avoid misunderstanding as regards the interpretation to be given to the undertaking. And C. Only give an undertaking which the advocate has the full control over the ability to fulfill. And D. Neither give nor accept an undertaking which, to the advocate's knowledge, the advocate giving the undertaking has no means with which to fulfill it. E. Where the advocate does not intend to accept personal responsibility for the fulfillment of the undertaking, make this clear in the terms of the undertaking given. F. Exercise diligence when accepting an undertaking from an advocate. Okay, those are the takeaways. But what did we have in preparation of SOPPEC number 9 before you? A professional undertaking is enforced in Kenya as a personal obligation of the advocate independent of the client's later refusal or inability to fund it. The court will summarily compel performance and allow execution once it is shown the undertaking was clear, unequivocal, and any stated conditions have been met. It is important to read Order 52, Rule 7 of the Civil Procedure Rules that provides for the procedure to enforce undertakings in the High Court, because the application is brought by originating summons in the suit if given in a High Court suit or otherwise, if the undertaking is given in a High Court suit, you approach court through chamber summons. But if it is an honor within a fixed time, and it is not dependent on a suit, you approach court through originating summons. If you read Section 60 of the Advocates Act, this is the umbrella provision for the disciplinary backdrop, because failure to honor an undertaking is routinely treated as a professional misconduct and can be subjected to a complaint and sanctions pursuant to Section 60. Then what counts as an enforceable undertaking? What is the undertaking test? Pursuant to Karaoke versus Bill Shimba Advocates 2023. A letter promising payment by a specified date was a clear and unequivocal professional undertaking, enforceable personally against the advocate pursuant to Order 52, Rule 7, and consistent with SOPPEC number 8. What is the test that was laid down? For enforcement, the court asked whether the undertaking was given by an advocate in professional capacity, clear, unequivocal, but not mere negotiation or we hope, or due. When was it due? What was the time? What was the trigger event? And if conditional, whether the condition was fulfilled. An advocate cannot introduce new conditions after the fact. Client disputes are not a defense. Rain and Hans Advocates LLP versus Kirika and Kirika Advocates 2022. The written undertaking was irrevocable and unconditional. The advocate's attempt to argue it depended on sale proceeds failed because that condition was not in the text. The advocate assumed the risk of the client default and was personally liable. Interpretation is by the written terms. The court enforces what was promised, not what the advocate later says he meant. What is not an undertaking? Subject to receipt of funds or third-party payment language. This was said in Njeru Nyaga Company Advocates versus Njeri Mburu 2020. Where ratio decidenda was that a letter that was dependent on receipt of funds from third parties and had uncertain timing was not a clear and conditional undertaking. Enforcement was thus declined. What is the test? If the promise is contingent on further contingencies upon receiving funds subject to case to sale, it is either conditional or not yet enforceable or too uncertain to qualify. Okay. Enforcement orders routinely include timelines and execution liberty. An unequivocal undertaking to pay 5 million was enforced. The advocate was ordered to pay within a fixed period, and execution allowed on default, underscoring the court's role in protecting the professional's integrity. How should students apply SOPPEC number 9? We irrevocably undertake to remit X amount to you within 7 days of registration of transfer. If transfer is registered, then the condition will have been fulfilled, and then the courts will compel for payment. Check at scenario B, subject to receipt of funds usually not enforceable as undertaking. We shall pay you once our client releases funds or upon sale completion. This is either conditional or uncertain and may fail the clear and unequivocal test. Scenario number C, advocate tries to rely on client refusal. This defense will fail. For instance, the advocate says client has declined to top up or the client is unreachable. Courts routinely treat that as irrelevant where the undertaking is personal and unconditional. Scenario D, undertaking given to court still enforceable by beneficiary. Undertaking recorded in open court to pay a sum to the other side. Advocate later argues it was only to court. Courts reject that as pedantic, and because beneficiaries can enforce that. Where do students go wrong? They treat undertakings as client promises. That is wrong because courts treat them as personal to the advocates once given professionally. Students ignore the wording. Everything turns on whether it is clear, unequivocal, and whether any conditions are expressed and satisfied. Students assume underlying disputes excuse non-performance. Students pick the wrong procedure. Students forget remedy structure. Okay? That is what I had prepared person to SOPPEC number 9. Let us go to SOPPEC number 10. SOPPEC number 10 is on the advocate's use of social media. This is a potential area in the Professional Ethics Paper 2026 November 2026. Expect something to do with social media. SOPPEC number 10. It is inappropriate use of social media, particularly in a manner that undermines the standing, dignity of the legal profession or amounts to professional misconduct. Additionally, material and content drawn from social media sites are relevant and may be taken into account by the regulatory authorities in dealing with the charge of professional misconduct. Social media are web-based and mobile technologies that turn text communication into active dialogue. They principally take the form of an online networking site. Such sites create a context in which advocates may form links to clients, judges, and other members of the legal profession. This can create informality of relationships among members of the network, which can potentially undermine detachment and independence in the performance of their work and create the potential for conflict of interest to arise. Social media provides a platform for short, quick messages to be disseminated widely. It is often the case that comments posted online are spontaneous and less than guarded. Such comments, if not carefully thought out, can damage the professional standing of the advocate, particularly when they express unconventional opinions or are controversial in nature. Social media also exposes the advocate's personal and social life online, and this might create an image of the advocate which undermines the advocate's and more widely the legal profession standing in the society. Social media sites may also be used consciously or unconsciously to promote oneself and solicit for work. Therefore, care needs to be taken not to breach the rules of the profession relating to advertising. Care should also be taken to ensure that comments made online are not intended to be relied on for legal advice, as this might create exposure to professional liability claims for negligent professional advice. Advertisement or solicitation for work on social media in breach of the rules governing advertisement amounts to professional misconduct. Social media offers access to wide audiences in a cost-effective manner, and for this reason, its use has grown dramatically in recent years, including by and among professional persons. Okay, so what did I capture from SOPPEC number 10 that the examiner can ask you? SOPPEC number 10 talks on advocate social media roles. Use becomes professional misconduct when it does the following: undermines the authority or dignity of the court or profession, breaches client confidentiality or privileges, amounts to improper advertising, or creates real and apparent conflicts where we have informal online relations with judges and parties. That is the test that the examiner will be expecting from a candidate. Then, professional discipline, where social media material evidences discourtesy, abuse, dishonesty, or abuse of process, courts may order corrective steps. Touting or commissions and improper procurement of work can be triggered where social media is used as a solicitation funnel, pursuant to Section 38 of the Advocates Act on touts and Section 37 of the Advocates Act on sharing profits with unqualified persons. What is the judiciary interpretation part? Attacking the judiciary in public publications can give you contempt, because criticism of courts is allowed, but publications imputing improper motive or dishonesty and calculated to lower the authority of the court amount to contempt. This is why you scandalize the court. Freedom of expression does not protect such attacks, and the test that was laid down is whether the publication goes beyond fair criticism and is calculated to bring the court into contempt or undermine its authority and independence. And a good situation is where the advocate twists that the judge was bribed or judiciary is captured without proof in a live matter. Contempt, exposure, plus disciplinary risk will fall on that advocate. Online decorum and professional courtesy. Court can order apology and undertaking, as was seen in the case of Aden Ibrahim Mohammed versus County Assembly of Wajir 2020. Even where disqualification is not warranted, the court may enforce professional decorum and require an apology or undertaking where the advocate conduct falls below expected standards, in and out of court. Okay. Social media as evidence of dishonest litigation conduct. This was seen in the case of Lokoko versus DPP 2025, where the ratio decided was that baseless, false, and unparticularized allegations, including against a judge or opposing counsel, can amount to abuse of process. The court can order referral to investigative and disciplinary bodies for perjury and subordination and professional misconduct. And the test here is that recusal requires that a fair-minded and informed observer will find a real possibility of bias and must be supported by cogent particulars and evidence. And a good situation is where an advocate circulates screenshots or claims online alleging ex parte meetings with the judge, then files recusal without particulars. Then another situation is where we have publishing or commenting on matters online. George Kiaka versus Kevin Kiriga, 2019. The ratio decided was that contempt is not presumed. It requires a valid, clear, and specific order and deliberate disobedience. Absent such order, contempt fails even if the conduct is distasteful. Whenever you're given a situation that emanates from online, run this in order. Test the court integrity. Does the post impute bribery, bias, or dishonesty, or ridicule the court in a way calculated to undermine authority? Run the confidentiality test. Does it disclose client affairs, strategy, privilege in communication, or identify a client in a way inconsistent with instructions or consent? Often the biggest OPEC 10 breach, even if not contempt. So take note that this is what an examiner can test on. Confidentiality test can also play part. Then another test that you should run is advertising or touting test. Then conflict and independence test, that the advocate's online relationship with judges or parties of friendship create a reasonable apprehension of compromised independence or impropriety. Then check on contempt mechanics text. Is there a specific order being violated? Non-publication, confidentiality, reporting restrictions. If not, contempt is harder, but discipline may still apply. Okay. So students usually ignore that advertising rules also apply on digital platforms. Students treat social media misconduct as a standalone offense. Okay. They overstate contempt. They understate judge bashing risk. Calling a judge corrupt online is not criticism, it can be contempt and trigger disciplinary referral. So students should take care of such situations. Then on the second last, SOPPEC 11, the advocate's outside interest. The advocate who engages in another profession, business, or occupation concurrently with the practice of law shall take care not to allow such outside interest to jeopardize the advocate's professional integrity, independence, or competence, or the standing of the legal profession. Outside interest include activities connected with the practice of law, such as directorship on corporations, as well as activities not connected to the practice of law, such as business, politics, sports, and the advocate's social life. Before engaging in other professions or businesses, there are two tests to be satisfied. The profession or business must be an honorable one that does not distract from one's status as an advocate, and it must be calculated to attract business to the advocate unfairly, which will be a breach of the advocate's practice rules. What are the examples of activities which can be seen as calculated to attract business to the advocate unfairly? One, we have the advocate becoming an active partner in an unlegal firm dealing with insurance agencies. That is one where the examiner can try to coin you around. The advocates registering a limited liability company to undertake on their own account company work and the registration of companies. Okay. This is where the advocate has registered a limited liability company to undertake on their own account company work and the registration of companies. C. The advocate joining or acting in association with an organization or a person whose business is to make, support, or prosecute claims as a result of death or personal injury in such circumstances that such person or organization solicits or receives any payment, gift, or benefit in respect of such claims. The advocate may only engage in outside interests which are compatible with the practice of the law. These are activities which are honorable and do not distract one from the status of the advocate or the legal profession generally. Indeed, the advocate may be guilty of professional misconduct if he assumes an office or engages in an outside interest which is incompatible with the practice of law or dignity of the profession. How did I interpret this part? Outside interest problems usually collapse into three enforceable hard law buckets. Do you have a conflict? We have a misuse of position or a public interest. Do you have situations that are prohibited under the Advocates Act, pursuant to Section 36, on using outside business that effectively procures legal work or shares legal profits with non-advocates? Undercutting, Section 36. Section 37, sharing profits with unqualified person. Section 38, touting. Section 39, advocate not to act as agents for unqualified persons. Section 34, Advocates Act, unqualified person not to prepare certain legal documents. Then another test is fee agreement invalidity. If an advocate acquires a proprietary interest in the subject matter or outcome, it can be treated as an invalid agreement. Pursuant to Section 46. What are the tests? Even though a legislature is not barred from all gainful work, acting as a counsel can be restricted where the advocate's public role creates a clear perception and risk of conflict of interest with official duties, because public interest can justify limiting counsel of choice. Is the outside role inherently incompatible with the brief, or does it create a real risk or perception of conflict undermining institutional integrity? Where the advocate previously acted for a party in matters forming the genesis of the dispute and likely holds confidential information, there is a risk and present danger of prejudice. The advocate is barred. Justice must be seen to be done. Generally, how is SOPPEC 11 operationalized in practice? This is the key takeaway that every student should understand. You think of a two-stage screen. You check on compatibility screen, honorable plus not a marketing vehicle. Does the side business procure claims or instructions or share legal profits with non-advocates? If yes, high misconduct offense risk pursuant to the provisions that we read out. Then you do the conflict screen. Ask, would a fair-minded observer see a real possibility that the outside role compromises independence or judgment or gives unfair advantage? If yes, courts may disqualify notwithstanding counsel of choice. If only speculative, disqualification will fail. And SOPPEC 11 gives us various situations: corporate directorship, insurance agency, company registration or side companies. These where advocates set up a consultancy where an advocate sell in corporation packages and the advocate signs documents. This can become enabling unqualified practice plus marketing misconduct. Where do students go wrong? They treat outside interest as automatically prohibited. This is wrong because the issue is compatibility, conflict, and misuse of the position, and not mere plurality of roles. Then we finish up with the SOPPEC 12 on honesty and integrity. Honesty and integrity is provided under SOPPEC 12. The advocate shall at all times maintain the highest standards of honesty and integrity towards the client. What is the rationale of this part? Honesty and integrity are the hallmarks of a member of the legal profession. By adhering to the highest standards of honesty and integrity, a member of the legal profession will promote trust in the profession. Dishonorable conduct on the part of the advocate, either in private or professional life, will reflect adversely upon the advocate, the integrity of the legal profession, and administration of justice. What are the elements that make up the concept of honesty and integrity? The advocate should not knowingly make a false statement of fact or law in the course of representing a client. The advocate should not fail to correct a false statement of material fact or law previously made by him or her, and must always demonstrate civility, personal dignity, candor, respect, and courtesy in his or her dealings with others at all times, including those over whom he has authority and control, such as staff members and those serving as pupils in the advocate's chambers. The standard on honesty and integrity also requires an advocate may not use unlawful or unethical means to advance the client's case. Examples include obtaining or advising the client to obtain evidence through unlawful methods, or suppressing or destroying or advising the client to suppress or destroy evidence or other information to the detriment of an opposing party, or advising a client to achieve an objective through unlawful methods or conduct. Remember, this standard also extends the advocate's mode of dressing when in public. The advocate is under a duty to dress modesty and in a manner that lends itself to the dignity of the legal profession. Where an issue arises regarding the appropriateness of the dressing of the advocate, whether male or female, this will not be held up lightly and will amount to professional misconduct. And the standard continues to tell us that it also extends to the advocate's management of his or her financial affairs. because whether personal or business finances, the advocate has a professional duty to meet financial obligations incurred or assumed in the course of practice or in private life. A pattern of neglect to discharge debts and other financial obligations undermines the standing of the advocate and dignity of the profession. And such a pattern can also attract disciplinary action. Lastly, the standard imposes on an advocate the duty of honesty and integrity extends to the conduct expected of the advocate towards all persons with whom the advocate comes into contact. At all times, the advocate should ensure or demonstrate courtesy and good faith. Any ill feeling that may exist between clients, particularly during litigation, should not be allowed to influence advocates in their conduct towards each other or the parties. Personal animosity between advocates involved in a matter may cloud their judgment and hinder the proper resolution of the matter. That is pursuant to SOPPEC number 12. How did I interpret SOPPEC number 12 before I end this recording? I beg for your indulgence as I look for the same, because it is the last part remaining. SOPPEC number 12. What are the key takeaways? Do we have tests? So basically the test and how to spot breaches under section SOPPEC 12 is that you ask yourself these questions. Is the conduct or dishonesty untruthful, or does it materially risk misleading the court or others? Does it undermine the administration of justice or public confidence in the profession? If private conduct, will knowledge of it likely impair client or public trust in the advocate's integrity? Then you check on discipline, where notice and hearing requirements met. We have concrete exam-ready scenarios that you can apply candor to the court. Advocates' files are without notice application and omits a pending similar application in another court. Risk of being treated as misleading and abusive. Then you have a false affidavit, where an advocate draft and commission an affidavit alleging a judge met the other side without particulars. Civility, where advocate uses abusive language in submissions and emails, personalizes the disputes, refuses to cooperate on routine issues. Disciplinary versus criminal. Student argues once disciplined you can't be prosecuted. Disciplinary fairness. Student assumes tribunal can proceed anyhow because it's not a court. So those are the tests or scenarios that you should be in a position to extract when it comes to SOPPEC number 12. Okay. So up to this part, I would like to give a special thank you for you as the listener, because you'll not only have understood SOPPEC rules, but you'll practice them by heart. You're not only reading it for the examination purposes, but you will be subjected to the same rules from day one of your admission as an advocate. Therefore, doing such activities is both morally right and professionally keeping you at par with what is happening in the ground. So we can do a summary so that it sticks at the back of your head. SOPPEC number 1 was on requirement for practicing certificate. Then the law knows that once you have acquired a practice certificate, you look for job. You'll want to advertise and market. That is SOPPEC number 2. Then in your endeavor, you have marketed and you have gotten a brief. You should approach this brief in a competent and diligent manner, SOPPEC number 3. And in exercising your diligence, you will charge. We have professional fees. And you will encounter a situation that the client has some funds and other properties. So you can have greed. SOPPEC 5 comes to cure that. And SOPPEC 6 contemplates a situation where even after being prohibited by SOPPEC 5, you decided to act on behalf of two adversarial clients or former clients. SOPPEC number 6 will come into play. Then SOPPEC number 7 knows that after acting of a client or in a current client, you decide to have or to expose a certain information from that client to the public, either through SOPPEC 7 as read with SOPPEC 10 of social media in social media, or there is a furtherance of an illegal activity. The law expects, or the society knows, that some advocates will engage in sharp practice, and in doing so, some privileges will not be protected. And Section 18 of the Pokamla Act says that even if the advocate-client privilege will not be protected, it can be qualified because the court's order will not extend beyond the advocate confidential information. There is a limit, there is a bar to the extent that the court's order can go. SOPPEC number 8, then they will know in your endeavors you are an officer of the court pursuant to Section 55, and you owe the court the fidelity to the law and to the due process. Then, in your endeavor, you will issue professional undertakings. We will capture that. SOPPEC 10, social media. SOPPEC 11, they know that advocates can be investors. They know you will operate various businesses, various entertainment hubs. SOPPEC 12, honesty and integrity, candor to the court and to the profession. In your dealings to the general public, will you promote honesty and integrity? Thank you so much for your observation and your listening, and that marks the end of the SOPPEC Rules Analysis 2026 with case laws and tests. We are ready to face the professional ethics paper because what we will be delving into with full force will be the conveyancing paper and commercial transaction paper. Thank you so much.